Hello, welcome back to my channel. I am a law student from Australia. My name is Joanne. Yes, I'm a law student. I'm halfway through my second year law student, and I have been seeing some stuff from Katie Joy posted, and we need to correct the record here because she is back on her train about the fact that she was never, ever not deemed a journalist. She's still on the fact that the court has deemed her a journalist and that everybody is lying. So we're going to go and do a little bit of a legal. We're going to have some legal talk today. We're going to talk about an affidavit, what the purpose of an affidavit is. Then we're going to talk about judgments and the importance of judgments or decisions that judges make, and again, why they are important, because we have to define the two. An affidavit is just a way to get evidence into court, and it's usually something that a judge reads in order to make up their mind. Sometimes they'll do oral submissions, sometimes they'll do written submissions, and sometimes they'll have affidavits, and they take all of that, then they sit down, and then they have to study the case law. What does the law say about such and such? What precedents are there in the matter of such and such? And then they apply all of that to the facts of the case. Okay, the thing is, it's about facts in issue. So we saw the determination the other day. Now, I have to give her lawyer some grace here, because at the point that they wrote their affidavit, the only determination was the one that they referred to that said plausible that she was a journalist. But whether she is or not, from all the reading that I have read on the matter, is what we call a disputed fact in issue, and that has to be contended or contested at some point in time. Where if both parties agree to things, it's a fact in issue. Where one says I'm a journalist and another party says no, I'm not, then it has to be contested and sorted out in court. Now, this has not been sorted out in court. The only arguments that they have had in the 7M case is regarding discovery. We're still doing this discovery. We have not even got to the point of whether defences of privilege or all that can be argued. That all has to come yet. So let's break this down. So let's first of all see what Katie Joy has said. Now, this is the alleged, and I say alleged. Okay, again, we just have a screenshot here. It is alleged. Okay. She's put this on her Instagram. She says, epic fail. Katie Joyless unveiled 9982. So obviously it's a fake account. Could be a sock account. You're a low-cal reality TV stalking, defaming YouTube channel. Thanks for proof for your lawsuit. With 7M loser, you are not seen as a reporter journalist, definitely not an advocate, just a wannabe with lots of fake subs. I watch 7K channels with 2 times in premieres and lives. No wonder you don't want to answer that. Take the L offer, 7M, and the Derek's $1 million to settle since you admitted you can't afford 2 Bentleys and brag on your channel so unprofessionally about every little purchase. So obviously have the money, or it is going for fake views and subs. This is embarrassing karma, proof you're no one but a fraud. All of YouTube is laughing at you. Exclusive. That was their 6th or 7th interview and rated worse because you can't interview when talking over people rudely and putting words in their mouth. This is a recent threat connected to my 7M lawsuit. Now, this apparently was under her interview. She says, this is such an oddly specific threat. Pay them $1 million or else. Where? Huh? And apparently, because I posted the video late at night and the premiere was a low count, that proves I have fake subs or followers. I will never settle with Robert Shin. I will never pay anyone $1 million for reporting on public records, court records, and interviews from former record members. I would never buy 2 Bentleys. Wasn't there a Bentley discussion when they were talking about Chrisley at one point in time, the Bentleys? That also, they always say narcissists accuse you of what they do. Well, she's accusing 7M of putting this out there. So, right, that phrase may come back to bite her. Based upon our research and following the comments and views on various accounts, we suspect they are the ones buying views, followers, and comments. But why? What do they need to achieve by doing any of that when they're actually not they're not talking about it? And who cares if that's what they're doing? Got nothing to do with it. And my recent video with Hannah and Celia Baron, and I don't make it for the purpose of getting into this interview, was for a specific audience, and they are the ones that watch the video. Sorry, something just downloaded and sent my computer into over. Oops, I've just closed a stupid window. Anyway, I'm really sorry. I'm back. This threat has been given to my lawyers. Also, their MO is to say that I'm not a reporter because I have qualified immunity against claims of defamation, which the court already ruled. The judge told them they have a massive hill to climb if they were to win, which the judge seems to think is highly unlikely. And then, well, under there's content and you're very careful. And so her minions have come out to play. Someone needs to learn how AI writing works. Also shows very... I don't understand why the hate. If you don't like something, just scroll on. Who cares what people drive? When you die, you can't take money with you. Anyway. So there's that. So, again, she's referring to this lawsuit. Now, I believe she did... something here. Again, we're going to have a look. Here, this one. Robert Shin really hates point number 4. My attorney's declaration related to a frivolous restraining order claiming I was using an employee to harass people. Now, point number 4, I'll read it. Ms. Paulson and WOACB, you know what? I have a feeling that sounds like her writing, but anyway, Miss Paulson and WICB have been deemed by a court of competent jurisdiction to be a journalist outlet, which enjoys a qualified privilege against defamation claims. See court order dated 7th of February 2023 at memorandum page 4, attached to Exhibit 1. She's a busy journalist who's engaged in keeping up to date with multiple stories at any given time and keeps a clear record of her engagement and subjects and sources can be seen on multiple outlets. Now, here's the thing. Let's go to, this is, we are now going to look at this is a online law journal, law dictionary, which we as law students use. We often use Lex, the Cornwall Law School. It's just one of many. So an affidavit is a sworn statement a person makes before a notary or officer of the court outside of the court, asserting that certain facts are true to the best of the person's knowledge. Affidavits by both plaintiff and prosecution and defence witnesses are usually collected in preparation for a trial. In the event a witness testimony contradicts what they stated in their affidavit, the affidavit can be introduced as evidence to impeach the witness in accordance to Rule 7. An impeachment of this sort can potentially lead to criminal charges of perjury if the contradiction was made knowingly, intentionally, or involved a material issue. Okay, this is why you do for the penalty of perjury. Now, let's have a look at this federal. Now, this is American. So I've gone straight to the US stuff. So let's have a look. They don't usually like any party, including the party that called the witness, may attack the witness's credibility. Allows any party to impeach a witness by means of his deposition, has allowed the calling and impeachment of an adverse party. So it is possible that the lawyer's credibility could be called into account, because the affidavit, and remember, it's part of the evidence filed into court in determining whether or not so the judge's decision. Okay, so let's have a look. So this is Minnesota rules of practice. We'll go straight to the court laws. Okay. Unless otherwise specified in any court rule, the term affidavit means a document that has been signed, sworn, and notarized. B, a document that has been signed under penalty of perjury pursuant to that statute, section 358116, provided that the signature is affixed immediately below a declaration using substantially the following language: I declare under the penalty of perjury that everything I have stated in this document is true and correct. In addition to the signature, the running and the county and state where the document was signed shall be noted. All right. All right. So that's what an affidavit is. So an affidavit is really a document that the courts use to get it's just a simple way to get evidence into court. Now we have to go back. I just closed this page. We actually have to go back to the judgment that they refer to. So they refer to the judgment. We'll go back to the page. We'll go back to this. Oh, look, I'm really getting good at this switching between screens at the moment. So she says here, and I'm sorry I can't make it any bigger. See court order dated 7th of February 2023 at memorandum page 4. So let's go back. Let's go to the case in question. And let's have a look. I'm doing this real time for you because it's really important that we follow this through. And so that for the avoidance of any doubt, okay? So we have to find the judgment. So we know that there was a judgment filed on the 29th of the 1st. We'll get to that, or an order. We'll get to that, okay? But we're only talking about the one filed. I have to remember it reads backwards, doesn't it, for me? 7th of February, this one. We've got to go to this one, I think. So let's have a look at that. So this one won't open straight away for me. I've got to do it in another way. Yes. All right. Do you see it? No. That's the other one, I think. Oh, no, page 4. Yep, that's all right. That's it. So let me just open this one. Hopefully you can hear me if you can't see me. All right. Sorry about that. Okay. So we're opening up this order. So we're just going to replace. All right. So page 4. So let's go to page 4. 1, 2, 3, 4. All right. Okay. So this is page 4. So this is page 6. So this is page 4. So let me just show you how we got there. So we went from here. This. Okay, so we've come from here. We've clicked on Order Other, just here, View Document, okay? That has led us to this document here. Which was an order, and there was a few. It starts off with there was a default judgment motion, there was an injunction motion, there was the amended scheduling order was granted, and there were some new deadlines set. Okay, this is all being thrown out the window at this stage because we've they've got to order a new set of deadlines. So this was defendant's motion to compel. It was denied. Remember, she filed a motion to compel, and it was denied as being premature. And the protective order was granted in part, and there was a separate order for that. So there was all of that happened. Okay. Hello, Autistic Shrill. So we've got to this point. So then we get to this memorandum, okay? This is the memorandum that has been referred to in this document. And I'm sorry that if you think that I'm speaking, I'm really trying to keep this simple because it would seem that Katie Joy and her lawyers are having trouble grasping this process because she's saying Robert Shin hates point for my attorney's declaration relating to a frivolous. Remember, he wrote that on the basis of knowledge and belief. And at the end of the day, he can, as we have seen under the Minnesota laws, hi James E., under the Minnesota laws, he or they, whoever it is, could face perjury. And let me tell you, lawyers are also held to a higher standard than the general people as well, because lawyers are representatives of the court. So anyway, so we've got this memorandum. So we're going to now go to page 4 because this is what she is talking about. And she's talking about where she talks about that they have a higher standard. Yes, that is mentioned in here. But there's a part that she does not mention, and either they have some very poor comprehension. Now, as I said, I'm a law student. I'm only a lowly law student, So I, okay. So now we get to this better. In this matter, okay, so let's look at this paragraph first, okay? Because in this matter, by their conduct and the nature of their business, plaintiffs are almost certainly public figures. We've got the word almost certainly. So the word almost brings an element of I'm not sure. All right, almost certainly are public figures, which requires a heightening showing of actual malice to prove a defamation case. Okay, so again, we have a contention of fact that has to be. So defamation is, so a judge's job is to go on a fact-finding mission. And where there are facts that aren't obvious, they're what called a contested fact. Now, the judge is saying, based on what she's saying in this matter, the plaintiffs are almost certainly public figures. Now, KJ can say that they're public figures. Oh, that's all right, Autistic Show. The judge, so KJ's saying they're public figures. 7M will say, well, no, they're not. We've got a contested fact. So now both sides have to put in evidence to show whether or not that is true. So they're saying, the judge is saying almost certainly a public figure. Furthermore, defendants are plausibly a journalistic outlet which enjoys a qualified privilege. Again, we've got again, it's plausible. So you've got almost certain and you've got plausible, which imply that they're going to be contested facts, and both parties are going to have to they've either got to have a meeting of the minds where they agree, or the court is going to have to decide on them. With respect to the second factor, the defendants have a reasonable excuse for their failure to answer. Defendants argue they were anticipating further order from the court, giving them a deadline to file an answer following the court's denial of their motion to dismiss. While such an order may be customary, remember they didn't file properly. Rule 12 provides clear instructions to a party whose motion to dismiss is denied. However, defendant also argues that they were taken away from their office, remember, which the court finds is a reasonable excuse for their file to file an answer. Moreover, from correspondence between counsel supplied in their affidavit, it is clear to the court that the parties were engaged in active communication concerning the matter in the period of time, which the defendant's answer was due, evincing an intent to continue to defend and participate. The courts find the defendants have a reasonable excuse to answer. So, when we're reading those, so I'm interested to see, I actually would like to see the judgment on this matter that she had this frivolous thing, because I want to know whether the judge has referred to it. Now, if the judge and she is a journalist from that matter, then we could say, well, I'm a journalist because a court's decided that I'm a journalist. But at the moment, we have nothing we have nothing definite. Does anyone know anything about that matter? I should talk about Robert Shin and his sons when she said they could afford. Because I'd like to see all the court documents about that. Um, because I'm, as I said, I'd really like to see the decision on that, why it was thrown out, because I want to see whether the judge, because remember she says here, she says here, my attorney's declaration related to a frivolous restraining order claiming I was using an employee to harass people. I'd like to see the oh gee whiz, more. Oh dear, I didn't see this. Dear Robert Chin, your former dancers have said in court records that they lost work opportunities because of you and not because of false reports about you. Oh gee whiz, this is a journalist. Let me read. I'm going to read it exactly as it says it here. I'll see if I can make this bigger for you because this is hard. No, it won't let me go any bigger. All right. Robert Shin, your former dancers have said in court records that they lost work because your former dancers have said in court records that they lost work. I can't read this. This is too much. Your former dancers have said in court records that they lost work opportunities because of you, not because of false reports about you. Also, stop ignoring that Scott Hestonton is the person that contacted the LA Clippers about his concerns about the dancers before I even knew who he was or reported about you. He was a friend of Miranda's that was worried about her. You are the reason for all this. I'm sure Scott will tell you he was the one that did it. It wasn't me. Stop blaming me for something that I didn't do. Thank you. But you did the screenshots. You got screenshots. You've got screenshots. Is she now going to turn around and say that, hi, Joanne? Oh, she's just, in my opinion, she's digging a bigger hole. Oh, of course she is. So I would be really interested to see the judge's decision on that frivolous TRO, because even if it was thrown out, the judge would have had to make a determination. And it's the judge. The thing is, it's always the judgments and the court documents that are referred to. If, for example, why did he put court order February 7th, 2023, memorandum 4, and not Katie Joy's affidavit dated such and such? Why did he use the order? Because the order means something. It means that a court has determined something. So now we are going to go to the next one. So since that time, I saw something. Oh, that's right. I've got to show you the next thing that she's done because it seems to have disappeared off the face of the earth. Funny that. No, that's not it. She put something up about something being false, and I can't find it. I think it made it onto. I think I saw it on Twitter. Actually, because somebody questioned her about it, and let's have a look. I'm sorry, I'm looking to the side. It's just I've got my computer. Who had it? It was Balls, I think, had it. Otherwise, I think I've got it on my. I think I downloaded it on my phone. Oh, here it is. So I believe. All right, so this was what was posted. I think it's now disappeared, but thanks to Without Miss Balls for sharing this. So somebody said, she said false. She's lying. She's also not a loyal sub. So someone wrote, oh, that's on the Facebook page. Actually, didn't the first judge say it was plausible you were a journalist, but the second one specifically said the court had not made a final decision? If that's accurate, I'd hate to see you sanctioned by the court for spreading false info regarding the ruling. The document your attorney submitted in the RO case is not a court declaration. It's just a doc from your attorney. Please be honest with us, your loyal subs. And she says she's not a loyal sub. So she goes, Robert is so desperate to stop that from happening. I have no comments on if I am or not involved in the series, but I will say that Robert won't be able to stop anything through a frivolous lawsuit. He's been sued by 4 former dancers and several members which accused him of human trafficking, sexual battery, gender violence and fraud, to name a few. He denied all this. 3 separate women have filed police reports in LA County alleging sexual battery and are against Robert Shin. Despite these reports, the DA is yet to charge files against him. You know what? Anyone can make charges. There's got to be evidence. So, you know what? Anybody can report anything, and they're not going to do it unless they've got a case against him. So, obviously, there's no case against him. That doesn't mean that he's guilty. All right? No, Alka, my loyal subs, know the kind of man Mr. Shin is, and they know the only one that is lying is him. If you support that man and live in a world where you want him to win, you aren't loyal to me or the victims in this case. Robert's life is only going to get harder this year. Once the supposed series is out, I will be the least of his concern. I want to be clear. And then she goes, I want to be clear. I was deemed a journalist has privilege. Jeez. I want to be clear. I was deemed a journalist has privilege in my case against Robert Shin. There has been no ruling from a judge stating the court hasn't decided. The judge specifically told Robert Shin that he is a public figure, and because my job is as a reporter, I have qualified privilege from defamation claims. This means he has to prove actual malice. We just read the court report. It said that it was possible he was, remember? And let's go back and see what the wording was. Let's go back and check the order. In this matter, by their conduct and nature of their business, the plaintiffs are almost certainly public figures, which requires a heightened showing of actual malice to prove a defamation case. Almost certainly. Defendants are plausibly a journalistic outlet, which almost, we've got almost and plausible. That's what the court, that is pulled straight from the court. This means he has a high bar to prove his claims. He has to prove that what I reported had been reckless regard for the truth. I reported truth based upon public and court records. Sources were interviewed and many of them named directly in my post. No one that supports my work would ever support what Robert Shin does to people. They would also know what my reporting has been the same as every single outlet in the media, including Rolling Stones, Business Insider, New York Magazine, and The Sun. Robert is trying to stop a documentary that is being made about him. The reason he's suing me, in my opinion, is that he believes that he can gain access to anything I have on this film. At this point, Robert knows that something is coming. He has filed in multiple lawsuits. He's aware of a docuseries coming to a streaming platform. So that's what she's written. And Alka is not, in my opinion, as a student of the law, she's not lying. So what she said there is actually quite correct. It was a court declaration. It means nothing. So let's go and look at the next one. So on the 29th of the 1st, on the 29th of January, there was another order. And we have gone through this. We discussed it. We went through this. But for those up the back, and for those specifically for the lawyers of Katie Joy, and herself, let's have a look at it again. Now, this is the interesting thing. Remember how I said that the judge is about fact finding? Okay. One of the things the judge has written here, okay, the findings of fact. All right, findings of fact. What we know. The facts are, and where it's findings of facts, it's what both sides agree on. Both sides agree that 7M is a talent management company. All right. They agree that Paulson runs social media accounts. Fact. That there are 9 causes of action. Okay. And how we've got there. We've got conclusions of law, what the law says. Okay. Now, under the law, so we get down to the interrogatories, and she's ruling on interrogatories. Now, here she says, plaintiffs have demonstrated that the requested information relates to claim by her own admission. Ms. Paulson has a massive social media presence and discussed plaintiffs on several platforms. The sources and veracity of that information is relevant to the many claims asserted by the plaintiffs. The information is not overbroad, as it is limited to statements made and information obtained about plaintiffs within a specific time period. So, again, a statement of fact is that she has a large social media presence. We get down to point 7. Defendants claim plaintiffs are not entitled to much of the information sought by plaintiffs because of journalistic privilege and or because the information qualifies as journalistic notes. The issue of or whether or not Ms. Paulson is a journalist has not yet been presented to or decided by this court. To the extent that defendant maintains that the sources of some of this information are confidential informants or qualify as journalistic notes, they can provide that information to plaintiffs pursuant to a journalistic log. Now, this states that even if she is a journalist, she still has to hand over the notes. I'm going to make this really, really big. All right? And I'm going to highlight this for those up the back. And so if I was quoting this, so for example, you would quote this as 29th of January 2024, page 3. In fact, we would quote it as paragraph 6. We'd go para 6, and then it would be 3. Sorry, para 7 and 3, because paragraph 7 of page 4, isn't it? Page 4? Yeah, no, page 3. Paragraph 7 is where it is in question. Okay? That is what you would quote. That is the... and don't forget, the judge would have actually have read the previous judgment too. She would have read the previous judgment and saw that the judge had said it was plausible. But she's saying she's not seen anything in the court where this has actually even been contested or even argued. So there we go. So for those up the back. So she has to be very, very, very careful. But if someone has any of the court documents related to that TRO in wherever it was, I'd be very interested in the decision, because that is where we're going to find out. That's where we're going to find out what the judge determined. But so anyway, I thought, as I said, I just thought I would just put this in here. And sort of break this down. For me, I just think it's it's easier to say nothing, to be honest. You just say nothing. And I don't know where, she's saying about the fact that she believes that maybe they are, but they're not 7am are broadcasting all this. They're not even mentioning her. They're not giving her any time. Hi, Autistic Shield. They're not giving her any time. And Autistic Shield, do you know any information regarding that restraining order she allegedly got? Because I'd like to read the judgment's decision on that for why it was withdrawn, because I want that. I'd like to see what the judge actually said, because if the judge in that has said that she is a journalist, that actually holds credibility. But if the judge has just not even mentioned it and thrown it out and not even addressed it, it means that we've got no credibility. So if anybody's watching this has got that information, if you could find it for me or let me know, because I'd love to read that decision, because that's going to give us a lot of information. But at the moment, we've only got very limited. We've only got what she's shown us, and all she's shown us is an affidavit. We've only got what was submitted as an affidavit, and I have no doubt that it was thrown. Look, the judge can throw it out, but even when they throw them out, they always give a reason for why, and that's really what I want to see. And so, if she wants to give me more, if she wants to, have myself take her a little bit more credible, she needs to probably show me that stuff. But as I said, I think it's we know that the facts are. So there's two uncontested. I don't know Minnesota. I'm convinced that KJ has people in high places. Yeah, well, yeah, I don't know. So there's two facts that need to be contested. So once they've got the discovery order out the way, there's two tests that need to be contested. The public figure, and because, let me go back. I don't think the judge said anything in this about them being public. Like, there's nothing in here about them being public figures. Because just because you own a talent agency doesn't mean that you're public figures. Your artists may be public figures, but you may not be public figure. There's journalistic privilege. I don't think she made a determination about the public figure, because we've got the previous look. We've got it in previously, and I'll read it again for everybody. I know I'm probably just repeating myself ad nauseum, but I'm trying to make a point. So on the 7th of February, the judge said plaintiffs are almost certainly public figures, and that defendants are plausibly a journalistic outlet. It's interesting. She didn't say she was a journalist, a journalistic outlet. We're talking about two different things here. So a journalistic outlet is not a journalist either, by the way. Oh dear. And then we've got point 7. Defendants claim plaintiffs are not entitled to much of the information sought because of journalistic privilege and or because information qualifies as journalistic notes. The issue of whether or not Ms. Paulson is a journalist has not been presented or decided by this court. Now, they could appeal that decision. Usually you have a period of time in which you can appeal the judge's decision in the order. So, and I don't know that it's worth it, but there has been nothing filed on the court since the 29th of January. And we have a court date on the 19th of the 3rd. That is going to be a boomer. That's going to be amazing. I almost wish I could attend just for fun. But yeah, so that's where we are. So I don't understand this whole narrative of people lying. I have nothing to lie about. There's no reason for me to lie when I say that the court has not determined if Katie Joy is a journalist or that Without a Crystal Ball is a journalistic outlet. As a law student, integrity is something that is really crammed into us, and making sure that we make good decisions about things. The only out for the lawyer I can see is if they go based on will be if she's actually I mean, I sort of get the impression again that she wrote that affidavit and that they just signed it. But if they signed it without reading it, then that's full then. Oh, someone also just said this. Just curious, I read some docs that someone posted on Twitter that did show where the judge stated it had not been decided. I don't really care. I just think that is where everyone is getting this information from. Did your lawyer obtain a copy for you to read? Then she says, it's not how they are making it out. Trust me, don't patronize me and act like you know more about me than me. Also, you just outed yourself as a Robert Shinner supporter. Then this person says, I actually didn't. I don't even know what he does. I'm just stating I had read about a document. I was not even being snarky, legit was wondering. So there you go. So that's not how they are making it out. What does that mean? I don't know what that even means. I've just read straight from the court document. How can you misinterpret that? How can that be misinterpreted? I mean, I do have to read lots of law court documents as part of my study, and I have to read lots of judgments as part of my study. We've even had to all read the same judgment and write what we thought the judge was saying. So, but then, hey, at the end of the day, I'm just a lowly law student. But anyway, no, laws are definitely different in the US. I'm in Canada, but also above North Canada. I'm in the same time zone. Okay. Look, and I admit, I don't know US. I maintain I can only talk about Australian defamation laws and Australian laws. But court documents all read the same. It doesn't matter. You can read the court documents all read the same. And the fact, here's the other thing, where she put statements of fact, where she put findings of fact. Let me just go back a bit. So I can see there are two contested facts here, the public figure and the journalistic fact. And I'll tell you why. Because in her findings of fact, she's written here, though, 7 findings of fact. So these are agreed facts that they agree on, okay? Remember, the judge is a fact finder. Plaintiff 7M Inc. is a talent management company. Robert Shin is CEO and sole owner. Plaintiffs Miranda and James Derrick are husband and wife and associates of Mr. Shin. Plaintiff's business is in the field of social media communications and marketing. Additionally, they broker deals between performance, particularly dancers, and commercial venues. That does not say that there's not any mention there of being a public figure. It's just Ms. Paulson runs several social media accounts with substantial reach, numbering in the tens of thousands or hundreds of thousands of followers, particularly on Instagram and YouTube. Fact? Yes, we know that. Again, no mention of journalist. Says she runs. And then it goes into the allegations. But then we get down here. She says here, by her own admission, she has posted on her social media about them. And then we get to the fact that whether or not she's a journalist has not yet been determined. So that's a disputed fact that needs to be sorted out in the court. There's also and there's also nothing in here about 7M being public figures. So we would have to go back to the previous judgment for the public figure determination, which, to repeat, it says plaintiffs are almost certainly public figures. Almost certainly public figures. Okay. Therefore, if they're deemed public figures, they do have the heightened, they've got to be able to show actual manners. But you know what? I'm super behind, but Sue contests, but her piqued me. She posted a screenshot of her dashboard showing a sub count, and it had a parenthesis saying some purchased. It also showed comments and parenthesis 300 deleted. Oh, really? She showed a dash. Yeah. Hi, Vivian. So yes, so that's where we are. So we have to go back to the judgment of the order on the 7th of February for the plaintiffs are almost certainly public figures. And then we've got, that's the one where she's plausibly, and remember it says defendants are plausibly a journalistic outlet. Now, are we going to argue over semantics and say journalistic outlet? So that means without a crystal ball is a journalistic outlet, but it says nothing about whether she's a journalist. We're talking about a journalistic outlet and a journalist are two different things. A court can find that the outlet is actually protected, but the journalist isn't. Has happened. It's happened in Australia. Because somebody posted on their private page something, and so we want to get down to semantics. She was plausibly, it says the defendants were plausibly a journalistic outlet. So we're getting into semantics and detail. That's where we are. But yes, so I'll just reiterate, if anyone's got the order the judge made in that restraining order that was filed against her, where was that anyway? Was that in I should have been paying attention, because I want to see what the judge has said about it. because it's the judgments that we pay attention to, not the affidavits. And when we talk about court records, anything can be filed in court records. But the thing and that's just, again, evidence. That's just what the judge is just put there for the judge to make their decision. But they just don't sit there and go, oh, yeah, that's really good. They've got precedences, they've got laws and rules that they actually have to follow. But I do think that particularly in Minnesota, they could definitely question the integrity of that affidavit. I don't know whether that would be able to be submitted into evidence. Again, I'd like to hear what the judge's determination would be if they tried to put that in evidence, because the thing that baffled me, they even put that page or that memorandum in this court evidence, and the judge, if they read it, would see that that's not what it says. So anyway, all right, well, I need to get on and do some more work. I was just a bit worked up about the fact that she deemed somebody who questioned the fact that what the judgment said, the last judgment said, implying that they're a liar, and if you don't agree, you have to be a Robert Shin supporter. I'm not a Robert Shin supporter. I'm all about the law. I also have to tell you, I'm becoming very, very, very cynical about a lot of stuff regarding law these days too. Very cynical. So I see why they earn their top bucks, because everything is scrutinized. Everything is scrutinized. You don't believe anyone, you don't trust anybody. You just put everything in order, and at the end of the day, you have to represent your client the best that you're able to. KJ is sort of reminding me of in Australia, particularly in criminal courts, criminal cases. They reckon one of the things you don't ever do is put the defendant in the witness box, because you can't control them, and often they will dig themselves into a hole. And at the moment, that's what she reminds me of, that person that's speaking, trying to defend themselves, but making it worse. They do it. Sometimes there was a really horrible case where a guy drove a car down a really busy street and ran over a whole lot of people and killed them. And unfortunately, which was really unfortunate, his lawyer, who is one of my teachers, knew he was not right. You're a commentary channel that helps debunk misinformation, not my greatest description, but you might find something useful in that. Yes, well, that could be correct as well. But he said his client insisted on speaking, wanted to speak, and he knew it was fraught with danger. But he tried to get him deemed mentally insane. The guy he will tell you, this guy was the most insane person he's ever seen in his 25 years of being a criminal lawyer. This guy was totally insane, and he was having, and so he went, okay, we know this guy's guilty. we know. Guy kept saying he wasn't guilty, but he said, I knew he was guilty. He was guilty. But I had to, it came down to, we all knew he was guilty. We all knew he did it. He knew he did it. But he sat in there and tried to convince everybody that it wasn't him, and came across as being absolutely insane, and made it worse for him, because it really then just lengthened the time that he was going to be put away for, which was, hey, it served its purpose. The lawyer was right. He said he needed to be put away for a long time, where he couldn't hurt anybody. But he was also hoping that he could get some mental help, which I think did come. But he said, there's only very limited times that you will do that. You let your clients in the witness box, because they generally, to use a pun, hang themselves. And it is my view, my opinion, that she's currently hanging herself. And we've not heard anything from 7M other than them going about their business. They've let her do all the talking on social media. And let's face it, how can she prove that they're public figures if, how does she prove that they're a public figure? So all of this stuff will be contested in court. I imagine that is going to be that would be nearly a whole day's argument. The whole journalistic argument is going to be a whole day's argument. At least a whole day. Because you'll have KJ's side, we're journalists, and they'll put their case forward. You'll have 7M's side saying, no, she's not a journalist, and they'll put their argument forward. Then KJ's side gets to have the final word, and then it goes off for a determination. Often it will go off for a determination. So we're far from over, because that will have to be determined. That determination will have to be made, hello, Berta and Stella, before any of the witnesses are called and everything, just because they're at discovery stage. That has to be determined pretty early on if she's not wanting to still hand over her discovery. But again, that will determine how much, whether she's a journalist or not, will determine how much information gets released, gets put in evidence, gets to go into the trial. So it has to be a determination at some point. So it's something that needs to be done sooner rather than later. And if she's going to keep refusing to do discovery, nothing. There's been no court today, Alberta and Stella. She's just somebody questioned her about the fact that the latest judgment said that she wasn't. That the judgment said that it hadn't been determined, and she's essentially called everybody liars and that you're Shin supporters. So I just had to go back over all the previous. I've just gone back through everything, and the court judgment, to say that the judge has stated in the ref. I even gave reference points. It's order dated the 29th of January 2024, paragraph 7, page 4. Page 3. Paragraph 7, page 3. Sorry, page 3 is where it states that the journalistic privilege has not been determined by the court. However, Alberta and Stella, I did point out that in the one that she keeps referencing from the 7th of February, that it says that it's plausible that the defendant may be a journalistic outlet. So my point is that being a journalistic outlet doesn't mean that the other's a journalist. So being a journalistic outlet and being a journalist are different. So, and that the court also said on that date that the plaintiffs were almost certainly public figures. So didn't say they were public figures, almost certain to be public figures. So I've also explained the difference between agreed facts and contested facts. So the public figure status and the journalism status are disputed facts or contested facts, and so they have to actually go to court to be determined. Yes, she may be the program, but she isn't the CEO. So, well, just a journalistic outlet. Not everybody that works for a journalistic outlet is a journalist either. You think about not everybody that works at the Sun or Rolling Stones are journalists either. They might be financial people. They might be, yeah. So just because one is, the other isn't. So yeah, so she's been on a bit of a rant this morning about Robert Shin, and that all of this is a ploy, and that if you don't support her, you're a Robert Shin supporter. So yes, just because you work at the paper doesn't mean you write for the paper. Correct. You might be the proofreader. You might be the I mean, you might be the person that makes the coffees. I'd like somebody to make my coffee. So yeah, it means nothing. So I said if we wanted to get down to semantics, the actual wording is journalistic outlet. We want to get to semantics. So I don't support either of them, but she needs to be stopped. IMO. And then she's accused 7M of trolling her page. So I think that, to be honest, I think they got better. I mean, if they've got all these lawsuits that she's claiming that they have, they'd be more focused on dealing with their lawsuits than trolling her, wouldn't they? I mean, she keeps saying that she won't settle. Well, why would 7M want to settle with her? She's the golden goose that keeps on laying the golden eggs. Every time she's opening her mouth, she's helping she's helping them. Well, that's what I think, Alberta Stella. I don't think anybody I don't know anybody that would be really interested in her. So court, I think we said was, when did we say court was? Court's coming up on the 19th of March. So that is going to determine, they're going to do a new scheduling order, I think, is my understanding. That's like, I mean, Katie Jo will turn around and say, I don't know anything because I'm not from the US. And she's right on one thing. But I do know how to read court documents. Oh, that's why I've repeated myself a lot, Alberta and Stella, because I want it to get through. I want it to get through to them. So I keep repeating myself because it's important. But I don't understand it myself. Why she keeps harping on. If she wants to have a chat to me, I'm happy to talk to her too. I'm happy to have a discussion with her. I'm happy to explain it to her. By the way, I'm very happy to sit down and explain it all to her. I'm my legal office assistants. Well, that is true. That is true, Alberta and Stella. And as I said, it comes down to, and I also talked about how, oh no, she's still going. All right, here we go. There's more. But wait, there's more. This has been put on recently. Once Robert Shin and his history is fully exposed on major streaming platform. What if new details exposed are worse than anything I've reported? FYI, I don't know anything about what will be revealed or not be revealed. but this man is scrambling so hard to silence anyone through lawsuits, not realizing he cannot stop a moving train. Let me go back to here. Let's go back a year again. Yeah. You got that? Okay, I got that. Yeah. So she's definitely on a really punching the bear. Okay. So yeah, well, her comprehension hasn't been very. She hasn't been writing very well either. So I'd be about. She's also talked about. She wasn't the one that did the report to the sporting team. Oh, story's no longer available. She deleted them. Oh, that's right. This is the one where the LA Clippers. She reckons she didn't have anything to do with the LA Clippers in this one. It's just got music. No, it's got no sound. And then she's on to the Cody. And then, yeah, it must have been that other one's gone. Ooh. Anyway. All right, well, I'm going to leave it there. I want to thank you all for watching. Please make sure that you hit like and subscribe. And look, so I hope that I've corrected some misinformation out there. It's really, I have no words because people are asking her questions and very simple questions. Yeah, well, here we go. Oh, look, hopefully she does another Instagram live because that was fun. However, I do have to say I'm back teaching tomorrow. So I'm back at work tomorrow. So, yeah, I don't know when I'll be able to do all the information again. But anyway, I'll be around today and it'll be probably my late night if I do anything tomorrow night. But anyway, thank you for joining me. And look, hopefully I've happened to help that misinformation out there. I have, I'm more than happy to tell you what units I've done. If you need to have qualifications, you want to know more. I have done the civil law unit, and I've done the criminal law units, and I've done the evidence law units, commercial law. Yeah, so I've done quite a few. So I sort of getting to and I've been working on some cases as well, some employment law cases, helping people out, some criminal law stuff. So yeah. So anyway, I doing some stuff, getting lots of experience as a student lawyer. So anyway, I want to thank you for watching me. If you could do me a favor, hit like and subscribe. And yeah.